Hi, my name's Hannah Nezazan, and I'm an attorney with Monroe County Legal Assistance Center. I'm happy to be working with Empire Justice Center to bring you a few short videos to help those of you who need to access your unemployment insurance benefits. If you have recently become unemployed, you may be wondering if you should apply for benefits, how to do so, or if you're even eligible for them. The funding of these benefits comes from taxes that employers pay. These have never been taken out of your paycheck. Unemployment insurance is temporary income for workers who become unemployed through no fault of their own. You must be ready, willing, and able to work. You need to have worked long enough and earned enough wages to be eligible. If you have worked at least 2 calendar quarters out of the last 5 calendar quarters prior to filing your claim, you may be eligible. But these are all determinations that the Department of Labor will make after you apply for your benefits and they conduct their investigation. You can apply for unemployment benefits by telephone or by going online. That information is on your screen right now. When you apply for benefits, there will be a few things that you should have with you to make the process easier. You will need your Social Security number, your New York State driver's license number if you have one, your complete mailing address, a telephone number that you can be reached at Monday through Friday, 8 a.m. to 8 p.m., the names and addresses of all employers you have worked for within the last 18 months, even if they're from outside of New York State, and if you are not a U.S. citizen, you will need your alien registration number. If you have it, the Federal Employer Identification Number from your last W-2 for your last employer will be helpful. If you're a former federal employee or an ex-service member claiming benefits on your service, you will need additional information. I urge you to check out the Department of Labor's website if that's the case. You should file your claim the first week you become totally or partially unemployed, because this first week is a waiting period for which you won't receive benefits. As you go through the application, do your best to answer the questions completely and honestly. After you make the initial application, the Department of Labor may do a more thorough investigation, calling you and your employer with follow-up questions. Answer their questions clearly and honestly. After the department completes their investigation, they will send you a notice of determination regarding whether or not you will be receiving benefits. For more information on that, check out our next segment. And please remember, these videos do not constitute an attorney-client relationship. If at any time you feel you need representation or more legal information, I urge you to contact your local bar association or legal services provider. After you complete the application process, you will receive a determination on your benefits. This notice of determination will state whether or not you will be paid benefits and at what rate. The second thing it will tell you is what the Department of Labor decided about your case. And the third paragraph will tell you why the Department of Labor decided as they did. This paper is crucial to all the rest of the things that follow. At this point, you or your employer may request a hearing. If you are denied benefits and you want to appeal the decision, you have the right to a hearing in front of a fair and impartial administrative hearing judge. But, and this is very important, you must request this hearing in writing, and it must be postmarked no later than 30 days after the date that your determination was mailed. You will find the date that the determination was mailed in the top left-hand corner of your notice of determination. This is a very strict time deadline, and very few exceptions are made for it. Therefore, the safest way to protect your right to a hearing is to make sure you mail it out within those 30 days. Your request does not have to be fancy. Simply address it to the address you see on your screen now. It's a simple statement with your name, Social Security number, and the simple sentence that you request a hearing. Sign it off and mail it off within those 30 days. The other thing your notice of determination might indicate is whether or not the Department of Labor believes you willfully misrepresented the facts when you applied. This will be under the determination of whether or not you get benefits. If the department believes that you willfully misled them, you said something on your application that wasn't quite true, and it's indicated on the notice of determination, it will be a second issue at the hearing. To recap, once you get your notice of determination, you or your employer can appeal. If you want to appeal, you must do so within 30 days of the date mailed. The first issue at your hearing will be about the Department of Labor's determination about why you lost your employment. A second issue may be whether or not you didn't tell the whole truth on your unemployment application. But whatever you do, if you want a hearing, make sure you mail your request within those 30 days. Going to your hearing can be intimidating and scary, but unemployment hearings are set up so that people can represent themselves. You may go to your hearing at a hearing office, or your hearing may be conducted by telephone. But before you go, make sure you prepare. Reread your notice of determination and review the issues. Focus on the issue at hand. Gather your documents that may support your position and think about whether or not there are any witnesses you want to have there. There will be two issues at your hearing: why the Department of Labor thinks you were fired or terminated from your employment, and whether or not you told the whole truth on your application. This is the part about willful misrepresentation. Just to recap, make sure you check your notice of determination, and remember that once you get this, either you or your employer can request a hearing. You must appeal it within 30 days from the date the notice was sent. And check your two issues: why you lost your job and whether you told the whole truth on your application. Before you go to your hearing, you have the right to review your file at the hearing office. If your hearing is going to be by telephone, it'll be mailed to you with your hearing date. Your file will contain any documents that you or your employer gave to the Department of Labor during the investigation, and written records of conversations you had with the investigator. It's very important to know what's in your file. When you go to your hearing, be on time. If you're late, the hearing will start without you. The judge will ask you to tell your side of the story. Try to stay calm and collected, and speak up if you don't understand what the judge is asking you. It's okay to ask for a brief recess if you get too nervous or you're overwhelmed. At the hearing, your employer will also have the opportunity to speak. They'll get to tell their side of the story, but you'll get to ask your employer questions, so you'll have your chance to speak. You may bring witnesses and supporting documents for your case. The judge won't give you a decision that day. The judge has 5 days to make a written decision, and you'll receive it in the mail. If you disagree with the judge's decision, at that point you have the right to an appeal, provided that you do so in a timely manner. One other thing to remember that is very important: while you're waiting for your decision, you must continue to report to the Department of Labor about your unemployment benefits. So just go in, tell the truth, tell your story, and you'll be fine. Good luck.